Okay, hello everyone. I can see people joining our webinar, so that's good to see. We'll just give everyone a couple of minutes to join before we get started. In the meantime, feel free to introduce yourself on the chat box there. You'll see you can use that to introduce yourself, let us know where you're joining from, tell us a little bit about maybe what field you work in. Really nice to get an understanding of who's joined us today. See lots of people have joined through the waiting rooms. That's good. And we'll get started in just a minute. Okay, I think most people have joined. So we will get started. So welcome everyone to today's webinar. It's great to see so many people joining us from all over the world, which is really cool to see. My name's James. A few of you may have already talked to me before if you've shown some interest in the University of Manchester's online LLM in International Commercial and Technology Law. So I'm the course advisor for that programme. So I answer any questions that you have about that LLM and how to apply for online studies at the University of Manchester. Today, we are taking the opportunity to talk about an important topic that is related to that LLM, and that is on decentralized justice and a future of commercial arbitration. So I'm joined today by our program director, Dr. Joseph Lee Nazzini. So he is a reader in corporate and financial law at the University of Manchester. And he is also the program director for our online LLM in International Commercial and Technology Law. And also joined by Dr. Federico Ast, who is the CEO and founder of Claros. So I'll pass it over to our panel today just to give a bit more information about who they are and their backgrounds and their work in their respective fields. So I'll start with you, Joseph, if you'd like to tell us a little bit about yourself, please.
Hello, everybody. I'm Joseph Lee Nazzini. I'm the program director and the founding program directors of this LLM in International Commercial and Technology Law at the University of Manchester. So my background is commercial law, corporate law, and financial law, and also now looking into how technologies such as AI, blockchain, data analytics, and quantum computing can have an impact on commercial law and commercial law practices. So I'm delighted to be here and to continue our webinar series, and then and glad to have James and also Dr. Federico Ast to be here with me to deliver this webinar.
Hello, how are you? Federico Ast. I am originally from Argentina. I'm not a lawyer. My background is actually in economics and in philosophy, and then I have a PhD in business management. I just got interested in law and in arbitration in particular because I was living in a country like Argentina with a very slow, expensive, and sometimes even like corrupt justice system. And Claros was born out of my interest and I decided to try to transform this through technology. And well, I mean, I will tell you a bit more about that. But so I don't come from the world of law. I come more from the world of economics, philosophy, and some would say like a social entrepreneurship also.
Brilliant. Thank you for those introductions. Yeah, so this is a great opportunity to learn more about today's topic. So I'll hand over to you, Joseph, if you'd like to tell us a little bit about what the focuses of today, and you can get into some topics with Federico and share some of your insights with our audience today. Thank you.
Well, thank you. So good morning, good afternoon, good evening, and depending on where you are. And it has been a while since our last webinar, and I hope that our followers are well. And if you have watched our previous webinars on crypto finance and DAO, decentralized autonomous organization, you would know that there are growing disputes in these domains. For example, disputes can arise when crypto assets being used as payments or as investment. For example, we have seen payment service providers can also be involved in a contract dispute if a party fails to undertake the robust KYC program, know your customers, know your clients program. And in a DAO, there can also be disputes among power token holders over the business transactions, business directions, the organizational structure, or the rights and responsibilities associated with the power token. So these disputes can also they can be resolved in the court through traditional arbitration, ad hoc or institutional, through mediations, or via online dispute resolution platforms, ODR. So today we have a great pleasure to have Dr. Federico Ast, CEO and founder of Clearers, an online dispute resolution platform, to talk us about decentralized justice and how this concept and the technology embedded in the online dispute resolution platforms can have an impact on the future of commercial arbitration. So now I would like to ask you, Dr. Ast, a number of questions, and let's start with this one. So what do online disputes platforms do, such as Clearers, and how can they help commercial disputes online or offline? And I know, as you said, that you had a background in philosophy and economics, so you're an academic, but you're also a social entrepreneur. So why did you have this idea of setting up Clearers?
So the idea of online dispute solution is definitely not new. Like in the 90s, lawyers saw the rise of the internet and the opportunity of implementing digital technologies to resolve disputes. There's a bunch of projects that come from that time, but it was a bit early, right? And we have now the economy changed a lot, in the sense that many of the transactions that happen in the global economy is, imagine like a freelancer from Argentina who wants to sell like a website or a video for like a customer who is in London, right? And it's like a $1,000 contract. And then there is a dispute. And then, I mean, what is the client going to do from London? Is he going to hire a lawyer in Buenos Aires to try to go to court against, the contractor, or is he going to go to arbitration at ICC to try to collect the money back? So this is what the world economy looks like now, and traditional arbitration procedures are not suitable for this new economy. And this is even like a simple case. I mean, imagine there are cases where you don't even know who is the other person you are hiring. I mean, it might be some anonymous person, an avatar you met like on a Discord server or a Telegram group. You hire the person and you make a payment in cryptocurrency into like an escrow address, and then there is a dispute over the quality of the work. I mean, this doesn't fit at all with our understanding and practice of commercial arbitration. So the goal of Clearers and also other platforms trying to do ODR these days is try to resolve those small value claims that typically are starting to happen across jurisdictions, and they cannot be really resolved by traditional arbitration.
Thank you. So, so in the past webinars, we have also looked at fintech, financial technology, corporate tech, corporate technology, red tech, regulatory technology, and law tech and legal tech. I think Kleros is a type of law tech, a type of legal tech, and to be more specific, it is an arbitration technology, an ARB tech. Dr. Arsi, if you can share with us, what are the technologies used in Kleros and also commonly used in other online disputes resolution platforms? If you can share with us.
Yeah, yes, absolutely. So the main technology that is used in Kleros is blockchain. So why blockchain? Well, as you know, blockchain is a decentralized ledger that is immutable. And this, for a dispute resolution platform, has a number of advantages. So, for example, when you build something on blockchain, everyone can understand and verify that the procedure was carried out exactly as was planned. Like let's say we have a dispute, right? And we send this dispute to Kleros, this platform for arbitration. And then Kleros is going to pick a number of jurors, a panel of experts. Let's say, for a video, I sold you and then you're not happy with that. So Kleros is going to pick a number of experts, in video producing, and they're going to analyze the evidence and analyze the product, the contract we signed, and they're going to make a decision. Why this is built on blockchain? Because of three main reasons. First, because we want to make sure that nobody was tampering with the, contract that we did or with the product that I delivered. So that is one thing. There's this traceability there. Second, we want to make sure that the jury, this panel, is going to be picked randomly, and nobody is tampering with that. Nobody is putting their friends, or their family as jurors. So blockchain makes sure that everyone can trust this. And third, we want to make sure that nobody is going to be tampering with the vote counting process. So these three main elements are built on blockchain, and this makes sure that all of the parties who are participating in the transaction can trust that everything is happening transparently and that nobody is changing anything in a not a good way. So this is the first thing. So blockchain in some way delivers what you could in the traditional offline world you would call a rule of law or a due process, in the sense that everything is going to happen as was planned and nobody can make any arbitrary changes to the process. Okay. The second technology that Kleros uses is crowdsourcing or collective intelligence, in the sense that how are these jurors picked? Who are they? So there is a quite complex system of game theory where people get picked to choose to be drawn into a case. So people can select to be arbitrators in different courts. Each court is specialized in some particular type of cases. In this case, it's like a video producing a court. Then there's others about e-commerce, insurance, and many more. So if you want to be drawn as a juror in Kleros, you need to have a token, a crypto asset called Pinakion, PNK. The name comes from the old ID token that they had in ancient Athens to draw, jurors for their popular trials. So you get this token, you deposit the token into one of the courts, in this case, the video court. And the token is like a lottery ticket that gives you the right to be drawn randomly as a juror in cases happening in that particular court, okay? So you get drawn, and then you can see the evidence and you can vote. And then this is where the magic happens. So Kleros is based on a very specific concept of game theory called Schelling points that was developed by Thomas Schelling, who was Nobel in Economics 2005. And it's about coherence and reaching consensus in communities. So when you are a juror at Kleros, you need to try to guess how will the other jurors vote into the case, because you are rewarded if you have the ability of reaching consensus with them, and you're penalized if you fall out of the consensus with your vote, okay? So this is the magic of the game theory. I can go, further with this. This is a rabbit hole of how it works. I don't know how much do you want me to speak about? But this is a big innovation that Kleros brings in setting a number of incentives in the right way for the system to be secure first, and for people not to attack it. Second, for the system to be very fast. Kleros can resolve cases in like a few days and even like hours in sometimes. And lastly, for the system to be extremely cheap, because it's Kleros can produce decisions for like a few $dozen maybe. So it's really, really efficient compared to traditional methods.
Yes, thank you. So I can see that you know, the Kleros and also other online dispute resolution platforms are there to, you know, to kind of fill in the gaps, to make it for small claims, you know, so small value claims that are arising from, you know, online or offline transactions. And because of the use of the blockchain, for example, the claims and also the evidence, you know, be it digital or you know, non-digital ones will be, you know, uploaded on the blockchain, and to make the, you know, parts of the process more transparent. And as you mentioned that, you know, the mechanisms enables the dispute to be resolved more quickly. So, you know, speed is also of an essence in that kind of commercial, online commercial transactions. And also now you kindly also mentioned it's economical. Say, for example, when you actually have for example, a 1,000 or even 5,000, you know, pounds or dollar claim, you know, due to, you know, disputes arising from online transaction, it's very unlikely that, especially if you're based in different jurisdiction, to have the you know, the dispute resolved in the courts. And then, you know, the large arbitration institutions such as ICC, you know, perhaps they are not particularly interested, or even the arbitrators may not be interested in resolving, you know, smaller claims such as this. So I think that platforms such as Kleros and others, you know, have the ability to actually, you know, fill in that kind of justice gap. So, but then, you know, I'm going to ask an academic questions. You know, for example, and we also have arbitrators here online listening to this webinar, and as we all know that you know, arbitration emphasizes party autonomy and freedom of contract, a justice system through private contracting. So that links to the title. What do we mean by decentralized justice? And how is that different from other other commercial or other arbitrations or dispute resolutions, in terms of, I think you have also alluded to, in terms of the selection of the jurors or the selection of the arbitrators, the remuneration of the arbitrators. I think you also mentioned about the tokens and the making of the arbitral award, the decision, and its enforcement. How is that decisions or arbitral award enforced, online or offline?
Sure. So the idea of decentralized comes from different elements. I mean, from one side, like this is built on blockchain, which is a decentralized technology. So there is that aspect. Then there is another aspect that is, you know, this idea of crowdsourcing. You know, anyone who wants to be a juror in cases in Kleros can apply to be a juror and just need to get a token and then deposit this into the court where they want to work. So this is decentralized. Anyone can join as a juror. They will have to abide by the rules of the system, but they can, you know, participate in the same way like Wikipedia. You know, anyone can contribute to an article in Wikipedia, so anyone can be a juror in Kleros, as also in the same way that anyone can be a miner in the Bitcoin network. This is the idea of permissionless system where anyone can participate as long as they follow the rules of the system. So enforcement. Well, this is a big question. People ask, of course, all the time. There are two main ways to do the enforcement here. One of them is when all of the process is done on chain. Let's say I you hire me to build this video for you, and then you send a payment in cryptocurrency into a smart contract, and then this smart contract holds the money as an escrow, and then this is linked to Kleros in case there is a dispute. Dispute starts, goes to Kleros. I mean, you win the case. So Kleros makes a ruling, and then it tells the escrow smart contract, pay back Joseph his money. So the escrow smart contract is going to obey like the Kleros ruling, and then you get the money automatically, and there's no need to go to court, no need to anything, no, because this is self-enforced, okay? This is because of the nature of smart contract. So this works well for purely online disputes about, a video, the website, stuff like that. What happens if we want to implement this into a contract about like some rental of property? Well, now you will see that smart contracts are not enough, because you need to do some eviction, for example. You will need some, policeman to go to, a place, and you need to state recognition for this to be enforceable. And in this way, Kleros can work exactly as a traditional ODR method. It's a platform that parties agrees to use as arbitration, and then this goes to the platform. Platform produces, a decision, and then this is taken to a judge, a traditional court, and you tell the judge, look, we had this contract with this arbitration clause, calling Kleros in case of dispute. So there was a dispute. Kleros made the ruling. Alice won. So now please enforce it. So this is what happened basically for the first time in Mexico in 2021. There was a contract for a leasing of a property, and then there was a dispute. And the contract said Kleros is the arbitrator. This went to Kleros. Kleros made the ruling, and this was enforced by a traditional, judge in Mexico who ordered the eviction of the house. So it's like an ordinary, common dispute resolution, process. And by the way, in Mexico, now there is last year, there was a law passed by the Mexican Congress recognizing decentralized justice as a valid method for arbitration under Mexican law. So this actually would be legally binding in Mexico. So Mexico is the first one, and there's going to be like other countries implementing, I hope at least, this type of new legislation, including not just decentralized justice, but also other technologies like AI, for example, and others. But this is how the enforcement works. So either on-chain through smart contract, or like off-chain through traditional arbitration, enforcement.
I also had an opportunity to attend a number of arbitration meetings and conferences, and one of the feedbacks that I've got received from the arbitrators, especially the current practicing arbitrators, is that they're very skeptical about the online disputes resolution platforms, and often Kleros, the platform is mentioned. So congratulations, at least this is actually known in the arbitration world. But then often I felt that a lot of skepticism is they are not quite sure about the, as you said, the selection, the remuneration, and how is independence being maintained, and then also in terms of the enforcement. We know that when arbitral award is enforced in the courts, that concept of justice is actually quite quite an important element. So that's why I think there are many challenges in of this decentralized justice and implemented by online dispute platforms such as yours. But I think one of the biggest academic challenges, from an academic point of view, is how do you then ensure justice, and in particular the impartiality and the independence of the arbitrators or the arbitral tribunal, as you mentioned that it's selected randomly. So if you are connected with the parties, you cannot be selected. But then how can you ensure, say, for example, myself and James or other attendees at this webinar, we can also, put ourselves forward, and but then we may not disclose, all the information about us, or may not correctly disclose information about us. So how can your platform ensure that very important element in arbitration, that is the impartiality or the independence of the arbitral tribunal? Because this is often the case. That's if the arbitral tribunal is to award is to be enforced in the courts, then impartiality of the arbitrators it's a very important element that and then the parties may may challenge the award based on this ground. So how does your platform resolve this issue and ensure impartiality of the arbitrators or the jurors?
Yeah. So through game theory and economic incentives. So and this is a bit the part that is not easy to understand, especially for people who have training in law, because they are used to some particular way in which this works. So let's say you and I have this dispute, and then this goes to this court, and all of the people who are in the webinar who are like your friends, and I don't know because they didn't disclose properly, are drawn as jurors, right? So there is this case. Of course, they're going to vote for you, and then you know what? I can appeal, and if I appeal, there's going to be another panel drawn that is going to have twice as many jurors plus one. So I don't know if there is like 25 people here, and there's going to be another panel of 51, people there. And now, I mean, these 25 people can vote for you, but the other guys who are going to come in the next round, maybe you don't know them. Maybe they are my friends. And the idea is that everyone can also appeal. I mean, let's say you win again, I can appeal, and now you have 100 and plus jurors. So the influence you have because of the having friends of yours in the tribunal who didn't disclose properly their identity and their conflict of interest is going to start being diluted as the amount of jurors start increasing when there is more appeals. And let's say that people who voted in the first round for you, so how are they going to be rewarded? They're not going to be rewarded because of their ability to vote in the same way as the other people in the first round. The reward is going to come from their ability to be coherent with the last round that is going to resolve the case. So if this is going to be appealed like 3 times, what's going to happen is that for them to make money on the case, they will have to think, okay, what will this last panel of 500 jurors going to decide on this case? And I don't control them because this is a big panel. So what this makes jurors think is something like this. And this is the magic of the game theory here. How would the community of video producing people think about this case in general? What is the consensus I think the community would agree on to resolve this case? So if it makes the 3 jurors that you have in the first round try to think as the community, and this has 2 advantages. First, you kind of have a ruling made in the spirit of what the community would think, but you only need 3 people to do that. So it's very cheap, but still brings the same result as a community-driven, situation. Then this is the magic, and the fact that there is this appeal system that dilutes, the conflict of interest into the broader community. That is the combination of elements that makes Kleros work as very, swiftly and very cheaply, and with transparency that brings blockchain plus the incentive system that dilutes the conflict of interest. I know it's a hard pill to swallow, if you come from traditional arbitration, but Kleros has resolved already more than 2,000 cases, and you see this working again and again, and so it works.
Well, I mean, that's why we have, people like you as a philosopher and also economist to actually work in this area. And, yes, we lawyers, we do have, our own concept of justice, but, a lot of, the idea also, came from philosophy and also economics. So I think the online dispute resolution platforms gives an opportunities for us to explore and then to kind of revisit, some of the kind of more traditional concepts of justice or the practice of justice in the more kind of centralized, arbitration or, other dispute resolution. For example, mediation, and we see that different mechanism, different practices, in some jurisdictions they are more flexible with with the arrangement of mediation, by private contracting, through contracts, but there are also jurisdictions where the mediation contract will need to be validated by the courts, before the mediation to be upheld. So I mean, and then that all links to a different ideas of justice. For example, the justice systems in the UK will be different from justice system in another jurisdiction. And now we are all moving on to netism. A lot of our transactions are online, and for example, today we are based in different jurisdictions, but then we're working together, and then there will be issues on how do we arrange our transactions, and how do we arrange our what if we have a dispute, how do we resolve that? Are we going to select James to be our arbitrators or jurors, or are we going to for example, the attendees of today's seminar, they can be the the jurors to make decisions? So if we see ourselves as a community, and then we have kind of we are like-minded netizens, and then how do we resolve our dispute through a more kind of democratized justice systems? I think the idea is there, and the idea of having a decentralized justice. It's as you said, it's not new. And when we look at arbitration, through private contracting, it's a way of sort of moving away from a centralized justice system administered by the courts to kind of decentralized systems by the arbitrators, by the private arbitration institutions, but in some way, depending on the jurisdiction, supervised by the courts, especially when it comes to enforcement. So I also know that.
Let me comment something about this.
Yes.
You just said, because this is interesting. So Kleros is basically a method that makes decision in like a transparent way, where people can understand what are the rules for making the decision and all that. Okay. So this, many times we teach this as as arbitration, but this also could be seen as a mediation tool. I mean, which is part of a broader dispute resolution process. For example, there is this company. One of the customers Kleros has is a fintech company called Lemon, and they have disputes with the clients and customers because of chargeback situations, right, stuff like that. And then the customer goes to the customer service, and then they say, no, I mean, you're not right, we're not going to reimburse you. And then instead of just finishing there and leaving the customer with the only option of going to small claims court, which people typically don't go there, and especially young people, they just go on Twitter and bash on the company, which the reputational damage it produces. So they offer the option of going to Kleros for having a neutral decision-making process. And the company will abide to the ruling done by Kleros voluntarily, and the user does not have to do that. I mean, if he loses the case in Kleros, he can just go to small claims court, and this only takes like 4 days, and it's free for him. So in this way, this idea of the asymmetric, bindingness of the decision makes Kleros look more like a mediation tool, in the sense that it's not binding on parties. So if one party don't like the customer, he can just walk away from that. Okay, so that is one way in which this can be implemented. And also, there is another method that is more for commercial arbitration. You have a commercial arbitration process, and then you could use Kleros in order to resolve just one part of that, the expert witness element. So you break down the arbitration dispute into sub-items, and then maybe there is an agreement in like 3 of the 5 items, and then you send 2 items to Kleros. This is the spirit of a methodology that was developed by one of our board members, who is a dispute resolution professional called Rob Dean, and it's called the Kleros mediation bridge. It's like a med-arb process where Kleros is involved. So there are lots of different ways in which Kleros can be implemented. So even if we have been discussing this as a arbitration tool, it also can be used as a mediation tool by parties.
Yes, I mean you kind of preempt my next questions. In fact, we have seen med-app resolutions in some kind of statutory backed mechanism. For example, the Financial Services Ombudsman in the UK and also in other jurisdictions use a very similar ways to resolve disputes, but without the technologies, without that sort of online platforms. But then I suppose that concept of decentralized justice is not new, and then we have already seen happening in other venues. But then I think I think the novelty is it was used on a blockchain, and then perhaps also use other technology, maybe in future more artificial intelligence to help the jurors to make decisions, to make arbitral award, or maybe even using artificial intelligence to, in some parts, automate the enforcement processes, if not through the courts. Yeah. So my final question is, do ask questions, the online attendees. Feel free to type your questions in the chat. I think James will moderate the questions, and then then we can ask Federico to answer. So I know many sort of arbitration institutions, I'm not going to name them, they are also very interested in what you are doing, not just in the in Europe, but also in Asia. They are very interested in the development of the online disputes resolution ecosystem in that kind of decentralized way. So to what extent do you think that Kleros and also other platforms can be a game changer for the future of international commercial arbitration? For example, we're talking about the kind of arbitrations administered or taking place through ICC or LCIA, or for example, Singapore Arbitration Center, SIAC. What do you think that the technologies, the innovations that you have, or the arbitration technology that you are introducing to the commercial world can have an impact on, for example, the arbitration world, the arbitration establishment?
I think depends on which is the segment of the market. I get lots of arbitrators, from these traditional centers telling me, "Oh, you want to leave us out of a job?" I mean, we don't care about leaving out of a job big international arbitrators doing oil and gas, doing international commercial multi-million-dollar disputes. This is not what Kleros is going to resolve. And it's not the way in which Kleros could have a higher impact in the world. I mean, the way in which I see Kleros having a high impact in the world is by resolving like mid-market to low-market disputes. That is where the economy is going. I prefer Kleros to be able to solve, millions of small claims about websites, about this esports gaming, where metaverse people who don't even know each other and they still transact online over $100, $200, $5,000 maybe. But this is not going to be taking anyone's job, in the traditional arbitration industry. So this is for a different use case. So that this is a result of the new economy where we live. I mean, we are doing this webinar over Zoom. This was impossible in the past. I mean, if everything in the economy is moving to online and moving to digital connections, why shouldn't dispute resolution also do the same? It's a normal evolution. That's why I use a lot the idea of Wikipedia as a way to understand how this is evolving and how I think it's going to evolve. When Wikipedia started, people were like, oh, what is this? I mean, like anyone can be a writer in an encyclopedia. I mean, this is not going to be a very good encyclopedia because we know that Britannica already nailed the right way to do an encyclopedia. But, Wikipedia worked. It's not like the most trusted, academic, way to cite in papers or make references in books, but it solves many cases for lots of people in everyday life, right? So I can imagine Kleros going to this direction. People will use it for what it's usable for, and not for things that already have a solution developed over the ages. So there's no need to panic, anything. I don't know about AI. Maybe there is a need to panic about AI, but we are not like a core AI company. We are exploring a bit about with using AIs as jurors. Jurors can actually be AIs, but the use cases where we use this is more for disputes where you need more like a real-time decision. So, which is not commercial arbitration, but let's say there is a esports or a gaming tournament, there is a dispute over someone cheating or not, and you need a decision done in 1 hour because they need to play the next game in 2 hours. So AIs can do an almost real-time decision. So this is the type of use cases that we are seeing into AI and Kleros now.
It's like sports arbitration, for example, the game has to continue. You can't resort that to arbitration and then take months to make a decision and then you continue the game. Yeah. So I think quite a lot.
Imagine the VAR. It's the VAR, but using bots doing the decision almost immediately. And imagine the VAR not just decided by one referee and 3 guys in a room, but a crowd VAR, experiment. That is more or less what it looks like.
So James, I think that there are a number of questions in the chat. So perhaps you could, select some of the interesting ones.
Yeah, there are some very interesting questions in the Q&A and also in the chat. I think a few people have been sending their questions directly to panelists, so they're not visible to all the participants. But anyway, we can work through them and I'll read them out for context. But yeah, thank you very much for all that information and insights. It's really, really interesting. I have a few questions of my own as well, but we'll get through the other people's first and then see how we go. So we'll start with Mohammed's question. So he's asked about Kleros in terms of investment arbitration. So can you integrate that into that field, specifically solving discrepancies between, I'm not sure the pronunciation of this, is it BITs or bits, and seeing that whether the acts or states or investors meet the requirements of appropriate conduct?
I mean, if you are thinking of investment arbitration in the sense of a government against, company over some pipeline, that's not necessarily something that is going to happen very soon. But if you are thinking of investment arbitration in the sense of 1,000 people from lots of different countries who invested into a token project from the metaverse, and then there is a dispute on whether this project delivered on what they promised they would deliver in the ICO or not. If you consider that investment arbitration, then this is an investment arbitration tool that can resolve a number of claims that happen every day into the meme coin economy, if we can call it like that. So yes, that kind of investment arbitration, yes. Traditional investment arbitration between states and corporations, that's a bit more unlikely.
So a question of scale then. Yeah, so the next question is from Rob, and he asks, I think this is to do with the jurors, how they are selected on Kleros. So is provable human expertise important for the jurors on your platform?
That's a good question. Honestly, I mean, how do you want to, let's say I can build AI agent. The AI agent can analyze evidence, it's like a ChatGPT kind of tool. And I mean, maybe I don't even know, because what we know about jurors is that they are like behind an Ethereum address. And we don't know if what is behind that address is a human or a toaster or a fridge. It's what we can see is that it receives information and makes decision, and it is rewarded with an incentive system that well, Kleros defines. So it's a really good question, and this is part of the things we are experimenting now with AI court. Is this can an AI agent be trained in order to mimic the decisions that the equivalent human would make? Well, that puts us in a really interesting situation. Imagine you have an AI that can predict exactly how, I mean, the Supreme Court would rule in every particular case, or any court. This is not new. This is all of the predictive analytics, AI applications. And if you can have that, would I mean, and if 100% of the time it makes the same decision, would you use that? But there are like the moral implications of that. Is, let's say that you have a claim against someone, and the court system using this tool tells you, look, yeah, I mean, there's 99% of the odds that you will lose your case, so we're not going to send it to court because it's pointless. But there was 1% chance that you will still win. What does this mean for access to justice? I mean, these are the type of topics I have in mind right now about the implementation of these new mechanisms with moral imperatives of how we think of how justice systems should work. It's on the same level of this conflict of interest question. AI poses, in my view, like even more like Minority Report kind of serious question. So I don't really have a great answer for that. I do know that AIs are being better and better at simulating the decisions that humans would make.
Yeah, it's an interesting one to see how that develops further forwards. Oliver's asked a question here. It's quite a long one, so I'll try and condense it down. But I think the main subject of this question is about jurisdictions and international jurisdictions and different legal systems around the world. How would Kleros fit into that if you've got international bodies involved in this, and where does the decision lie if it's across different legal jurisdictions?
I mean, ultimately, the ultimate answer for the long term of this is that the jurisdiction is internet. Internet is the jurisdiction for this. We are not used to think of, for example, I don't know, Facebook as a jurisdiction or like Twitter as a jurisdiction, but we know when you have a dispute with another user, at Twitter, because of breaking the rules or harassment or stuff like that, this is a decision that is being done currently by a moderator, coming from Twitter, an employee, following the internal rules of Twitter for dealing with those type of disputes. I mean, would you call Twitter a nation state, a jurisdiction? I mean, maybe it is because they have rules, they have enforcement mechanisms, they appointed like judges who make the decision, and the decision that is done by a Twitter moderator that can like ban you from the platform can be for you more consequential than what would a judge make, because if they ban you, you lose all of your followers, your customers, whatever. So that is why what we are seeing lately is, have you seen that Facebook developed, this Supreme Court, they call it, so to try to bring some semblance of fairness and due process to a process that is currently done internally as a business process of the platform or the company. How this interacts with traditional jurisdictions, that's a really good question, and I don't know. I mean, there's going to be changes, I guess. There's already been changes, but yeah, this would take many books to answer. I don't really have a great answer for this.
Okay, well, thank you very much for the answer anyway. That is all the time we have for questions. I will have to wrap up because I think we could talk for hours on this, because I think what's nice actually to hear in this conversation, so I'm not a lawyer, I'm not from a legal background, but I can see how it might apply to me just as a regular person if I came across a situation where I needed some kind of place to resolve an issue with a company or another party. So yeah, it's really interesting to see from a sort of non-lawyer perspective how this might develop, and one day be protecting our rights in some way and fighting our battles in some way for us. So that's really cool to hear about. So thank you for sharing all that. I'll just finish off by just making a link to our online LLM, which is in international commercial and technology law. So some of the topics discussed today by Federico and Joseph link very well to the content that you could study on this course. So the University of Manchester has launched this online LLM in international commercial and technology law a few years ago, and it's a part-time master's degree where you can explore some of these topics, financial tech, things related to international commercial arbitration, and how technology might be changing the landscapes of these legal systems. So it's a really pioneering and innovative course to study if you're looking at exploring these legal fields in more detail. It's an online master's degree, part-time, which you'll complete over 2 years. Our next enrolment is in September, and we are open to applications currently. We do offer a 10% early application discount if you apply before June 30th, and there are also online other discounts for alumni from the University of Manchester. So if you've studied with us previously, that is available. It does say 2024 there, I just realized, so just bear in mind the next intake is September 2025. I need to update that slide, but yeah, it's 2025, not 2024. If you would like to learn more about the course, feel free to get in touch with me. I can be reached at studyonline@manchester.ac.uk. You can also learn more about the course at our website at manchester.ac.uk/techlaw, and feel free to take a look through there to learn more about that course. But that pretty much brings us to the end. I do think there was a few more questions, but we just don't have the time. Maybe we'll have to arrange another event, because this has been very interesting. Thank you, Federico and Joseph, for sharing all that information. And yeah, it's been really interesting to listen to. Hopefully it's been valuable to everyone else that's joined today. Yeah, thanks for joining, and get in touch if you're interested in any more of these topics or our online LLM. Bye for now.
Goodbye. Thank you.
Thank you.